discussed what looked like an ambiguity. You're saying there is no ambiguity in Section 3?
Let me take the point specifically about electors and senators, if I might, because I think that's important. Presidential electors were not covered because they don't hold an office. They vote. And this
No, I'm talking about the barred office part of this.
Exactly. So the barred office is, if you want to include everybody, first you have to specify presidential electors because they're not offices, so they wouldn't fall under any office. Second of all, senators and representatives don't hold office either. The Constitution tells us that under the incompatibility clause and refers to them as holding seats, not offices. And so you want to make sure that there's no doubt that senators and representatives are covered. Given that the Constitution suggests otherwise, you have to include them. The Constitution says the presidency holds an office, as do members of this court. And so other high offices, the president, vice president, members of this court.
All right, let me ask you, I appreciate that argument. If we think that the states can't enforce this provision for whatever reason in this context, in the presidential context, what happens next in this case? I mean, is it done?
If this court concludes that Colorado did not have the authority to exclude President Trump from the presidential ballot on procedural grounds, I think this case would be done, but I think it could come back with a vengeance because ultimately members of Congress may have to make the determination after a presidential election if President Trump wins about whether or not he's disqualified from office and whether to count votes cast for him under the Electoral Count Reform Act. So President Trump himself urges this court in the first few pages of his brief to resolve the issues on the merits, and we think that the court should do so as well.
And there's no federal litigation, you would say?
Well, that's correct, because there is no federal procedure for deciding these issues, short of a criminal prosecution.
Thank you.
Thank you, counsel. Ms. Stevenson?
Mr. Chief Justice.
Mr. Anderson. No, Stevenson. That's right. I'm sorry.
Mr. Chief Justice, and may it please the court. Exercising its far-reaching powers under the Electors Clause, Colorado's legislature specifically directed Colorado's courts to resolve any challenges to the listing of any candidate on the presidential primary ballot before Coloradans cast their votes. Despite this law, petitioner contends that Colorado must put him on the ballot because of the possibility there would be a supermajority act of Congress to remove his legal disability. Under this theory, Colorado and every other state would have to indulge this possibility, not just for the primary, but through the general election and up to the moment that an ineligible candidate was sworn into office. Nothing in the Constitution strips the states of their power to direct presidential elections in this way. This case was handled capably and efficiently by the Colorado courts under a process that we've used to decide ballot challenges for more than a century. And as everyone agrees, the court now has the record that it needs to resolve these important issues. I welcome your questions.
Is there an express provision with respect to that defines what a qualified candidate is?
No, Your Honor, there's not an express provision. When the Colorado Supreme Court looked at this, they looked at the need to be qualified, plus the fact that this part was.
So what does it say then? If it's not express, how do we get to this issue of qualified candidate?
What the Colorado Supreme Court did, and let me, if I could have a standing objection, I do want to make the argument that you shouldn't review the court's statutory interpretation.
No, I'm just looking at the statute.
Right. What the court did was to say that we have three important provisions in this section that show that candidates have to be qualified. First, it requires that under 1203 2A, that a political party that wants to participate has to have a qualified candidate. It also looked at the fact that the comparable write-in candidates also had to be qualified.
No, but this isn't a write-in candidate, so we're actually talking about the participation of a political party, right? We're not talking about the participation of a candidate.
Sure, I think that the fact that the write-in candidate also had to be qualified was confirmatory of the fact that the political party candidate also had to be qualified, and it would be otherwise incongruous to read those things differently.
So how is Section 3 a qualification?
Under the reasoning of the Colorado Supreme Court,
no, just on its face.
A candidate must meet all the criteria for eligibility, and I don't perceive any distinction between meeting the eligibility criteria and not being disqualified. I just don't see any meaningful difference between those two things.
Thank you.
You represent the Secretary of State, right?
That's correct, Your Honor.
If you're the Secretary of State somewhere and someone comes in and says, I think this candidate should be disqualified, what do you do next?
Administratively, and what the Deputy Elections Director testified to at the hearing, is that if they obtain objective knowable information, the Secretary can act on that and inform the
So the
candidate.
Secretary at first decides whether that's objective knowable information.
In some instances. In this case, the challenge was actually brought before the candidate's paperwork had even been submitted. And because there had already been a challenge asserted and put into the proper court procedure, the Secretary didn't even make that determination because she didn't have the paperwork.
Well, what in another case where that wasn't the procedure that was filed, somebody comes in, maybe they've got a stack of papers saying, here's why I think this person is guilty of insurrection. It's not a big insurrection, something that, happened down the street, but they say this is still an insurrection. I don't know what the standard is for when it arises to that.
I think anything that even presented that level of controversy about one person having a set of facts that they said prove this would send this case to the 113 procedure that we use to resolve ballot challenge issues like that. And if another elector or the individual who brought the information didn't want to bring it, the Secretary herself could bring that action.
Is there a provision for judicial review of the Secretary of State's action, both in Colorado and perhaps what you know about other states?
Well, certainly in Colorado, if any action that the Secretary takes that anyone wants to challenge, they can use the 113 process to do so. I think states have varying degrees of that. There's certainly other states that allow versions of that. And then I don't know whether there are others that don't. I certainly know that there are some that do.
I think we're told that there are states that do not provide for any judicial review of a Secretary of State's determination. Is that incorrect?
No, I think that's right. And I think there are some states that actually have no mechanism to come to, I think, Justice Kagan's point, or there are some states that don't have any mechanism to exclude a disqualified candidate from the ballot at all. And I do want to speak to that for just a minute about the actual
Would that
impact
be
of
constitutional if the Secretary of State's determination was final?
I think so under Article 2, the Electors Clause, Your Honor, that would be constitutional. States get very broad authority to determine how to run their presidential elections.
Could a state enact a statute that provides different rules of evidence and different rules of procedure and different standards of proof for this type of proceeding than for other civil proceedings?
Yes, Your Honor, I believe it could, under the same Electors Clause power.
That issue would be determined under perhaps a different constitutional provision like the Due Process Clause, correct?
Correct. The bounds of the Electors Clause are other constitutional constraints, which would include due process, equal protection, First Amendment.
What's the due process right? Does the candidate have a due process right? What's the liberty interest?
I think it's not very precisely defined in the case law, but I think there is a recognition that there is a liberty interest of a candidate, and there is some due process interest in being able to access the ballot.
I thought that was for voters. You think for the candidate too, that it would be taking something away from the candidate?
Certainly, yes, and I think a lot of times you see that in the First Amendment context where candidates can have an issue about being on the ballot, but it's sort of a hybrid, oftentimes First Amendment, 14th Amendment, qualifications clause, all discussed together.
Let me ask you a question about, just follow up to Justice Alito. These decisions might be made different ways in different states. Maybe a Secretary of State makes it in one state with very little process, or a process more like Colorado's could be followed by others. Would our standard of review of the record vary depending on the procedure employed by the state?
I think this court has tremendous discretion to decide its standard of review, and it might be based on the process that was employed by an individual state. I think you could exercise the independent review of Bose Corp that Mr. Murray talked about, or you could give deference where you have a full-blown proceeding like the one here that had all the protections of rules of evidence and cross-examination and things like that.
I'm sorry. You think we should give deference in reviewing the factual record, the legal conclusions? In other words, we shouldn't undertake a de novo review?
I don't think the review should be de novo. However, I am amenable to the suggestion that the court would do the Bose Corp type independent review that might provide greater certainty to states around the country as to what the court's position is on the factual record in this case.
Of course, if it were not de novo review, we could reach disparate results even on the same record, right?
I think that's possible.
I take it your position is that this disqualification is really the same as any other disqualification, age or residence or what have you.
That's correct.
And what if I were to push back on that and say, well, this disqualification, number one, it's in the 14th Amendment, and the point of the 14th Amendment was to take away certain powers from the states. Number two, Section 3 itself gives Congress a very definite role, which Mr. Mitchell says is interfered with by the ability of states to take somebody off the ballot. Maybe number three, it's just more complicated and more contested. And if you want, more political. And why don't all of those things make a difference in our thinking about this qualification as opposed to any other?
And so, Your Honor, I think the trouble with categorizing the insurrection issue as necessarily more difficult is it's just an assumption that's coming up, I think, because of this case. And again, back to the Chief Justice's point, we could have a very easy case under the 14th Amendment with an avowed insurrectionist who, came in and wrote on his paperwork, I engaged in an insurrection in violation of the 14th Amendment. And it would be an open and shut case as to whether or not that person would meet the qualifications to be on the Colorado ballot. With respect to your other questions about the 14th Amendment, my positions are based on the assumption that under the 14th Amendment, the states have the power to enforce Section 3, just like they do other presidential qualifications. And I would defer to the electors' arguments on those points.
Suppose a state that does recognize non-mutual collateral estoppel makes a determination using whatever procedures it decides to adopt that a particular candidate is an insurrectionist. Could that have a cascading effect? And so the decision by a court in one state, the decision by a single judge whose factual findings are given deference, maybe an elected trial judge, would have potentially an enormous effect on the candidates who run for president across the country. Is that something we should be concerned about?
I think you should be concerned about it, Your Honor, but I think the concern is not as high as maybe it's made out to be in particularly some of the amicus briefs. And again, under Article 2, there is a huge amount of disparity in candidates that end up on the ballot on different states in every election. Just this election, there's a candidate who Colorado excluded from the primary ballot who is on the ballot in other states, even though he is not a natural born citizen. And that's just that's a feature of our process. It's not a bug. And then I think with respect to the decision making, and we're here so that this court can give us nationwide guidance on some of the legal principles that are involved. I think that reduces the potential amount of disparity that would arise between the states. And then with respect to the factual record and how that gets issued and implemented, the states have processes for this. And I think we need to let that play out and accept that there may be some messiness of federalism here because that's what the Electors Clause assumes will happen. And if different states apply their principles of collateral estoppel and come to different results, that's okay. And Congress can act at any time if it thinks that it's truly federalism run amok.
Justice Thomas, anything further? Justice Alito?
Well, just one further question, and it's along the same lines of a lot of other questions. We've been told that if what Colorado did here is sustained, other states are going to retaliate, and they're going to potentially exclude another candidate from the ballot. What about that situation?
Your Honor, I think we have to have faith in our system that people will follow their election processes appropriately, that they will take realistic views of what insurrection is under the 14th Amendment. Courts will review those decisions. This court may review some of them, but I don't think that this court should take those threats too seriously in its resolution of this case.
You don't think that's a serious threat?
I think we have
We
processes.
should proceed on the assumption that it's not a serious threat.
I think we have institutions in place to handle those types of allegations.
What are those institutions?
Our our states, their own electoral rules, the administrators who enforce those rules, the courts that will review those decisions, and up to this court to ultimately review that decision.
Justice Sotomayor? Justice Kagan? Justice Kavanaugh? Justice Jackson, anything further? Thank you, counsel.
Thank you.
Rebuttal, Mr. Mitchell?
Both Mr. Murray and Ms. Stevenson rely heavily on the electors clause and the authority that it gives the legislature of each state to direct the manner of appointing presidential electors. But that prerogative under Article 2 must be exercised in a manner consistent with other constitutional provisions and restrictions. And Justice Kagan alluded to one of those restrictions that might be imposed by the First Amendment, but there are others. A state cannot use its power under Article 2's electors clause to instruct its presidential electors only to vote for white candidates. That would violate the Equal Protection Clause. But nor can it exercise its power in a manner that would violate the constitutional holding of U.S. term limits against Thornton. And they cannot use the electors clause as an excuse to impose additional qualifications for the presidency that go beyond what the Constitution enumerates in Article 2. And the problem with what the Colorado Supreme Court has done is they have, in a way, changed the criteria in Section 3 by making it a requirement that must be met before the candidate who is seeking office actually holds the office, effectively moving forward in time the deadline that the candidate has for obtaining a congressional waiver. There has still been no answer from the Anderson litigants on how to distinguish the congressional residency cases, where the courts of appeals, not decisions from this court, but the courts of appeals in applying this court's holding in U.S. term limits have unanimously disapproved state laws requiring congressional candidates to show that they inhabit the state from which they seek election prior to election day. And there still, in our view, is no possible way to distinguish those from the situation below in the Colorado Supreme Court. Mr. Murray also invoked the de facto officer doctrine as a possible way to mitigate the dramatic consequences that would follow from the decision of this court that rejects the rationale of Griffin's case, and that also agrees with Mr. Murray's contentions that President Trump is disqualified from holding office on account of the events of January 6th, and that he's covered by Section 3 as an officer of the United States. This court's recent decisions in Lucia and Arthrex held that officers who were unconstitutionally appointed under Article 2 and that made decisions under the APA that were attacked as invalid, those decisions were still vacated, and this court did not use any variant of the de facto officer doctrine to salvage the decisions that were made by these unconstitutionally appointed officers. There is no way to escape the conclusion that if this court rejects Griffin's case and also agrees with Mr. Murray's construction of Section 3, that every executive action taken by the Trump administration during its last 2 weeks in office is vulnerable to attack under the APA, and further, that if President Trump is reelected and sworn in as the next president, that any executive action that he takes could be attacked in federal court by anyone who continues to believe that President Trump is barred from office under Section 3. I'm happy to answer any other questions that the court may have.
Thank you, counsel.
Thank you.
The case is submitted.
The Honorable Court is now adjourned until Friday, the 16th of February at 10 o'clock.